This is SJC-13200 in the matter of an impounded case.
Attorney Alpert?
Yes, I'm here. For some reason, my video is not working, even though I tested it this morning. If you can give me one moment. I'm so sorry. It's giving me an error that it's failing to start the video. If you want me to just go orally.
Yeah, don't worry about it.
Okay.
Go ahead.
Good morning, and may it please the court. Caroline Alpert for the juvenile. The Commonwealth and the court were not satisfied with the maximum sentence available at the time the juvenile tried to plead. So they used a continuance as a mechanism to avoid that sentence and obtain a longer deprivation of liberty. This was not good cause for the continuance for three main reasons. First, the language of Section 58 provides age-based caps on sentences, and there is no discretion for deviation. Second, this was an Article 30 violation because the court and the Commonwealth essentially rewrote the sentencing statute to give them the sentencing power that they wish that they had. And third, the Commonwealth intentionally delayed a case to obtain a harsher penalty, which is prohibited under Mogolinsky 2 and EULA U.
Well, counsel, can I ask you a question? Part of the purpose of the juvenile statutes and scheme is to rehabilitate the juvenile, whereas diversion over into the youthful offenders system might cause more incarceration and fewer services. Is the juvenile better off in some instances? Would there be some cases where even a defense attorney might say, let's let this juvenile get some services in the juvenile system? Or do you think that it's possible that this will now cause the Commonwealth to always move for youthful offender indictments?
Well, I think that what's important to remember is that rehabilitation with juveniles is not just confined to the time that they're committed to DYS. So even if you're committed for a short time to DYS still sets those juveniles up for having services within the community.
Do they do that when they're when they're older than 18?
So generally,
No, or if it's a 19-year-old situation, that change works. Do they do that does the DYS do that even if they've passed out of the juvenile jurisdiction?
So generally, in my experience, as a child is approaching that transition time where their commitment is going to end, part of what DYS is doing is setting that child up for success in the community. And I will also note that there is a provision that juveniles can sign on to DYS until they're 22, even after their commitment period ends. So there are still ways for juveniles to access services with DYS, and also DYS is not the only social service agency available to juveniles and to youth. So there are a lot of ways.
Let me just stop you there. That takes care of the services, but what about Justice Cypher's point that if given the option, the Commonwealth will just go for youthful offender status?
Certainly that would be allowed by the statute on the cases that are eligible for youthful offender, which is a narrow range. And I don't think there's anything.
Okay, well, let's talk about that narrow range. Let's talk about those cases where they could go for it and perhaps will now go for it if they don't have this option.
And they might, and I don't think there's anything that I can do to stop that. But I would hope that they would still utilize their discretion in deciding which cases really warrant going on the youthful offender track versus delinquency, and wouldn't just use this decision to automatically indict every case. But I think the real point here is that we could all have opinions on the amount of time that kids need to spend in DYS and perhaps have a good faith disagreement about that. But the point is that the legislature put very clear age-based caps on what the maximum sentences are, and the only body that could change how that would work would be the legislature. And this court, in many circumstances, there have been cases before it where juveniles have completely escaped prosecution, which is not the case here. And I cite many of these in my brief: Commonwealth versus a juvenile, the Santiago case, the Delmore D case. And even when there are scenarios where this court might not agree with the outcome of the case, or there might be a juvenile who might not get as much of a sentence, as long of a sentence as a particular judge might think is warranted, that does not give the court authority to override what the legislature has written in as the sentencing caps.
Counsel, let me ask you a question about the other side of this coin. There was a lot made of the Commonwealth dissatisfaction in manipulating the request for continuance to circumvent these caps. What about the tails to that coin, though? That a defense counselor would have a case that was open and would know what the maximum amount was, and it'd be a month before the changeover for the birth date that they tender a plea and say, we'd like to do a plea, knowing that there was only this finite amount of time that's available for DYS custody. What about the flip side of that? Would defense lawyers be able to manipulate it equally the same way and say, rather than do it in month 12, I'm going to wait till, pardon me, rather than do it in month 1, I'll do it in month 11?
Well, I think that the same rule would apply to defense counsel in the way that they wouldn't be able to continue or delay cases for this purpose. So if they saw that a birthday was coming up in 6 months, they couldn't purposefully delay for 5 months to limit that time. And I think I think the apples to apples comparison would be if a juvenile attorney said in court, I want to continue this case until right before the birthday so that he only has a short commitment period. I don't think a judge would ever allow that type of continuance. And so that would be applying the same rule equally to defense attorneys and the Commonwealth. But I think the other example of this would be a defense attorney moving swiftly on a case. And I don't think that that has the same problems that this particular scenario involves. I think that we expect juvenile defense attorneys to move very swiftly on cases. The time standards in juvenile court are much shorter than in adult court for a variety of reasons. If there is going to be a consequence, it's much more effective for a juvenile to have that consequence close in time to the behavior. And also, as the legislative scheme on a whole is trying to move kids in and out of the system as quickly as possible, for all of the social science research that explains why it's longer is not better, more is not better, that we should move quickly and return these kids to their community to be connected with community services, school, living with their families, things of these sorts. So I think if a lawyer is moving swiftly, that's okay. But if a lawyer is purposefully delaying to get close to that birthday, the same rule that I'm asking for in this case would apply. And I also want to touch on the Article 30 issue here, which is that as I note in my brief, I do think this is an Article 30 violation because both the court and the Commonwealth are essentially saying, we wish we had a longer sentence available to us, so we're going to use this continuance to get around the way that the statute is written.
But here, it may have violated the spirit of the statute, and I get your arguments regarding the abuse of discretion and the continuance in not taking the plea. But here, the judge didn't do anything that violated the statute. I mean, the words of the statute don't say he can't do or she can't do this, right?
They don't explicitly say you cannot do this.
Right. So how could it be an Article 30 violation when the judge followed, although you didn't like the result, but the judge followed the statute?
I don't think that the judge followed the statute here because I think we have to look at the intent of
what words in the statute did the judge violate?
So the way that the Section 58 is written for delinquency, it says that as a case is disposed of before 18, a commitment period shall not be for longer than until the 19th birthday.
Right, and the judge says, I don't want to hear it. I'll dispose of it later, post 19. But there's nothing in the statute. The judge had the ability to do this legally. Now, whether the judge abused, I think it's, it's a female judge, I believe. But anyway,
yes,
whether a judge abused her discretion in allowing the continuance and not taking the plea is a completely different matter.
So I do think Your Honor is correct that a huge crux of the argument is the intersection of Section 58 and the good cause for the continuance.
I just think your Article 30 argument is overstated. That's all.
Okay, and perhaps I could explain a little bit more why I think the intent of what the legislature was in the sentencing statute to help us understand that argument better. So when we look at the statute, the way that the delinquency sentencing is written, it's not written as a menu of options for judges to pick from. It's written as mandated caps based on when a case is disposed of. And I think there are several statutory canons that help us see that this was not written to be a menu of options, and it was not written to provide discretion. So for example, if we look at the statute as a whole, when you read the youthful offender portion, you can see there that there is specifically discretion afforded to judges. There is a menu of options of sentences that you can provide to youthful offenders. And there is a very lengthy description of the standards and factors that judges use in using their discretion to afford these sentences. But when you look at the delinquency portion, that is clearly absent. And so the legislature contemplated in what scenarios they wanted to provide more discretion to judges. And they contemplated in what scenarios they would want longer commitment times. For youthful offenders, a DYS commitment can be up to 21. And they confined those types of extensions to youthful offender cases only.
I understand your argument, your Article 30 argument.
Thank you, Your Honor.
Ms. Alpert, why don't you talk about Mogilevsky, if you can, please, in the 72A situation where there might be a purposeful delay.
Sure, and Your Honor, I think is referring to Mogilevsky 2, which is where the Mogilevsky 1 was when you could not bring an indictment after 18. And as a result, the prosecutor then moved for a 72A transfer hearing, and that came back before this court as Mogilevsky 2. And in that case, what this court discussed, they did not find bad faith or inexcusable delay in that case, but talked about the risk, hopefully rare, but the risk that a prosecutor could purposefully delay a hearing so that they could proceed by a 72A transfer hearing rather than in juvenile court. And what this court says in that case is that a bad faith or inexcusable delay to achieve that result would be prohibited. And so I think by analogy, we have the Commonwealth purposefully delaying a case with the intention of having a more serious deprivation of liberty. And so even though they're transparent about it, that still does not create a justifiable excuse for intentionally delaying a case. And this court reaffirmed this principle in the recent case of Eula U as well.
Counsel, may I ask you a question? Do you think the Commonwealth did that solely because they just wanted the juvenile to do more time? Or do you think they were also concerned, as maybe a judge was, or sometimes district attorney's offices have rather rehabilitative or lenient juvenile justice policies? Is it possible their intent was not bad faith?
Absolutely, and I'm not alleging that it's bad faith, and I think there could be again different reasons for thinking that a longer commitment time is better. But the point is that they were seeking a longer commitment time, and any way you define that or dice that, that is a significantly longer deprivation of liberty for the juvenile.
Well, one thing I was curious about, we don't have findings. The only thing I saw in the docket was, motion allowed, motion denied, depending on who brought the motion. There were no findings and there was no transcript. Did the judge say anything?
My understanding, Your Honor, and I was not the trial attorney on this case, but my understanding was that the Commonwealth filed a motion, which is in the record, that they entitled a sentencing memorandum. And in the opening line of that, they say, we are asking to continue this case after the birthday so that we can commit the juvenile to DYS until 19. So it's very explicit, the one and only reason. And the court then allowed that motion over the juvenile's objection. And so even though
it was all in the papers, so we don't have a court hearing. That's what you're telling me?
Correct. We do not have a transcript on this because procedurally this came up through a 211-3. And so we were somewhat confined in what we could include in the record.
Can I ask, they could have brought this case as a youthful offender case, right?
Perhaps they would have to have had a grand jury proceeding, and they would have to prove that in addition to the elements of the crime, that there was a threat or infliction of serious bodily harm. So if they could do that, then yes.
So I guess the question, and this may not be possible, but could we conclude that, given the rehabilitative purposes of, the juvenile laws, that it would be improper in a case where you couldn't bring a youthful offender indictment, but it would be proper where you could, because it would be clear that the Commonwealth's only purpose is rehabilitative as opposed to sort of manipulating the amount of time in DYS.
I think in either scenario, if a case is confined to a delinquency case, either because it's not eligible for youthful offender or because the Commonwealth in their discretion decides not to proceed on youthful offender, that means that they are confined to the delinquency sentencing portion of 58.
I'm just worried about the two consequences that Justice George and Chief Justice Budd brought up, which is the possibility of manipulation by the lawyer for the juvenile, and also that you're going to drive the Commonwealth into youthful offender prosecutions. So I'm just looking a way of avoiding that, but it may not be a way. But.
Chief, if I could ask perhaps a last question. Thank you. Counsel, what happens to your client if, say, you win? They passed September 2nd, I believe, was the birth date, that they're going to be incarcerated perhaps till 19 now?
Correct. So what would happen is there would be jurisdiction under 72(a) to have a hearing to impose whatever the ruling of this court was. And if this court did agree with me, if he proceeded with the plea, there would be a colloquy, there would be a plea and an adjudication entered on the record. But sentencing wise, it would have to be a DYS commitment to 18. So in effect, he would not serve a DYS commitment time, but it would be reflected on his record.
So he doesn't get to 19?
He does not, if this court agrees with me.
Okay, thank you.
Thank you.
Thank you. Attorney Hartley.
Good morning, and may it please the court, Brooke Hartley for the Commonwealth. This court should affirm the juvenile court's grant of the Commonwealth's motion to continue the juvenile's case past his 18th birthday. This case is an effort on behalf of the Commonwealth and the judge to ensure that the purpose of the juvenile justice system is carried out. The statutory scheme here is clear that we do not treat children as criminals. And time again, this court has interpreted that to mean that the purpose and goal of the juvenile justice system is rehabilitation. So with that in mind, I would like to briefly address the statutory argument and then move on to whether in general it is within a judge's discretion to continue for the purpose of extending the rehabilitation period, and then finally address the specific circumstances of this case and whether or not the judge abused her discretion here. So I think the Commonwealth and the juvenile agree that Chapter 119, Section 58 allows the juvenile court to retain jurisdiction until a juvenile is 19 if a case has not been disposed of. And under 72 subsection A, that includes during a continuance. So from the Commonwealth's perspective, the only question here is whether the continuance is proper. And of course, this court reviews that for an abuse of discretion. So turning to the abuse of discretion analysis and why in general, it is within the juvenile court judge's discretion to continue a case for this specific purpose. The Commonwealth's position that there was, I think you're on mute, Justice Wendlandt.
Counsel, can I ask you to also address Justice Gaziano's question from the Commonwealth's perspective? If we conclude that this has been an abuse of discretion, what happens to the juvenile?
I agree with my sister that the juvenile would plea and nothing, there would be no rehabilitation period at this point.
Let me ask you, I think it's your last point, but I'll ask it now. With the circumstances of this case, it seems to me that this judge, when you read through the record, was bothered by the subsequent behavior, the gun and the violation of probation and the like. what Mr. Alpert says is, well, punish them for the gun if they're found guilty. Wasn't the judge supposed to sentence this person for the domestic violence A and B and not take into account the other crimes?
I think the judge was certainly entitled to consider, yes, the nature and circumstances of this crime and the A and B household, but also the escalating nature of this individual's criminal record. I think that's something judges do in every context, whether it's.
I would hope, when people haven't been found guilty of crimes, judges don't take that into consideration, but maybe I'm wrong.
I think it certainly weighs less on the scale, but I think when a judge makes a bail determination, for instance.
That's bail, but anyway, this goes to the abuse of discretion. I think if you read between the lines, at least the way I read between the lines, is this judge had enough of this juvenile's behavior, given the escalating nature of it, and decided, I'm not going to give this person a break. They're going to go until the 19th. Is that how you read the record?
Not exactly. I think it's also about whether this person could be rehabilitated in that 2-week period. And from the Commonwealth's perspective, and I think probably from the judge's perspective, that 2 weeks is an illusory rehabilitation period. The purpose of the legislature was not going to be accomplished in that short period of time, given the fact that, given the nature of this crime and the escalating criminal record. I think
you have options. If it was that bad, you could YO. Right,
so,
and then you can seek commitment on the gun case if it was found guilty.
Actually, I would like to, and I intended to point out a misstatement in my brief. I do not believe that the juvenile here could have been indicted. The underlying offense here was not a felony, which is a prerequisite under the YO statute. So the Commonwealth did not have that option in this case. I think it's still an important point. I think that there are certainly going to be many cases where the Commonwealth would see rehabilitation in the juvenile justice system as a better option than indicting a juvenile. But if they are left with the option of this illusory period of rehabilitation, whether it's 2 weeks or 2 days.
So 2 weeks in custody is illusory?
From the Commonwealth's perspective, yes. The rehabilitation that is intended by the legislature could not be accomplished in that short period of time under these circumstances. I don't think that we can have a bright line rule or a test or any specific factors that are applied to every case. And that's the nature of the analysis of the continuance, the abuse of discretion. But I think in this case, the judge determined, and the judge was within her discretion to determine that 2 week period would not effectuate the intent of the legislature.
Isn't prejudice to the defendant part of the continuance calculus?
So I think that goes to my sister's due process argument.
I'm still talking about abuse of discretion for continuance.
I think, yeah, certainly. I think, if this were a 6-month period of time, or perhaps if it were his first offense, the consideration would be different. So yes, I think the prejudice to the juvenile is part of that analysis. There's no question. I think the Commonwealth's position is that although this is not a sentence, this is not punishment in the same way that it would be in the adult system, there obviously is, and the court has said before that it is in some capacity a liberty deprivation, but it's certainly not the same as incarceration or punishment in the adult system. But yes, I think we take that into consideration.
Counsel, though, the part that I'm struggling with is, isn't this always going to be some measure of concern to the Commonwealth, given the structure of the statute? There's always going to be a 12-month period, 11th-month period heading toward the birthday, right? So
Sure.
Isn't there always going to be some line, I don't know what it is for the Commonwealth, where they would say, Judge, we want a continuance because we just don't think there's enough period here until the birthday turnover for any kind of rehabilitative work or therapeutic work or any other things that were driving the Commonwealth's consideration here. Isn't that just a necessary consequence of the way that the statute is structured, that sometimes that might happen for the Commonwealth?
Sure, and I think sometimes it will happen. I think there are certainly cases where it would not be in the interest of justice and there would not be good cause to continue the case. But I disagree with my sister's characterization of the statute as having these these hard and fast lines. I think that the statute certainly has some age-based restrictions, but the legislature has intentionally made these restrictions flexible and given judges under certain circumstances the discretion to extend these age-based restrictions, whether it be 18, 19, or 20. The statute is flexible in that respect.
Counsel, what words in the statute are you relying on to make that conclusion?
So I'm looking at, if you look at section 58, it allows the juvenile court to retain jurisdiction until the juvenile is 18 and 19 if a case has not been disposed of. And that includes a continuance. So I'm specifically focusing on the language that under 72 subsection A, the meaning of final adjudication during a continuance is not a final adjudication. So I think that's why
manipulate the continuance in order to get to past the 18th birthday if 2 weeks in the Commonwealth's estimation is illusory.
Well, I disagree with Your Honor's characterization that it's a manipulation of the statute. I think the Commonwealth was within its right to move for a continuance, and then it was up to the judge to determine whether there was good cause for that continuance and whether it was in the interest of justice. And I think if we look at the cases from this court, I think there is good cause in general under certain circumstances that a continuance would effectuate the intent of the legislature, which is the rehabilitation of the juvenile. And I think we can look at the fact that juvenile court judges are vested with broad discretion in different contexts, several different contexts. First, they have broad discretion to determine disposition that furthers the goal of the juvenile justice system. They are tasked with making difficult discretionary decisions about whether to transfer an offense or to dispose of an offense. And I think we can also look at this court's interpretation that the legislature did not intend for juveniles to fall between the cracks. And of course, this is slightly different than Commonwealth v. Porges, where the court found that under 72A, the Superior Court has jurisdiction if a juvenile committed a crime before 14 but was apprehended after 18. And the court said that if the Superior Court did not have jurisdiction, then this certain group of juveniles would fall through the cracks. And so the Commonwealth's position is that the same thing is true here. And whatever the sentence is, 2 weeks in this case, perhaps it's 2 days in another case, the results would be the same. This juvenile would fall.
Ms. Hartley, I want to go back to an issue that Justice George has raised that wasn't answered. If the Commonwealth can't do this, and can't seek a continuance for this purpose, what if the juvenile is a week or two away at arraignment from 18, and the juvenile wants to offer a defendant cap plea on a relatively serious case, and the disposition is going to end up being 2 weeks, and it's right at the beginning of the case. Would the judge be able to say, I'm not going to take that plea and deny the continuance?
Would the judge be able to allow a continuance and not take the plea?
Not take the plea.
Yeah.
And grant the continuance. If we would rule against you here, would the judge still have that discretion?
I think so. Of course, the juvenile has no right to a criminal defendant, or a juvenile doesn't have a right to plea and doesn't have a right to have a plea accepted. Obviously, there's a slight difference here, which is that the Commonwealth put on the record and the judge allowed the continuance based on the fact that the Commonwealth thought that it wanted to extend this rehabilitation period. So I think that it is a little bit different, but I think it is instructive to how the court should rule here. Because yeah, I think there are certainly circumstances where a juvenile might be arraigned a day before his 18th birthday and want to plea right then, and the judge would be well within his or her discretion to not take the plea on that day. And I think we can look at Rule 12 of Massachusetts criminal procedure that says the judge may continue the plea on the judge's own motion to ensure that the judge has been provided with and has considered facts that are pertinent to whether the plea provides a just disposition. So it's the question here is right on point with that rule, although we have that sort of intermediary step of the Commonwealth saying we want to continue for this purpose. But what the judge was doing here was considering whether the plea provided a just disposition, and ultimately the judge concluded that it did not, and allowed the continuance.
How do we know that? Where do you get that? Because the judge here didn't make any findings, right? So where do you glean that?
Sure. Well, I think the allowance of the motion after the Commonwealth filed the motion for those reasons is what I'm gleaning that from. But Your Honor is certainly correct that we don't have any findings on the record. And if I may, I would like to briefly address my sister's Rule 30 argument. I think I touched upon this, but the Commonwealth's position is that the legislature did not impose mandatory sentences here. There are no sentences. Instead, we have these age-based restrictions that are flexible. And also to briefly address her due process concerns about whether this would offend fundamental fairness. I think there are two questions here. First, the Commonwealth, or excuse me, there has to be actual prejudice to the defendant. And then we also have to consider that actual prejudice doesn't necessarily mean there's a due process violation. So the cases the juvenile cites, I don't think are directly on point here. First, she cites JH v. Commonwealth, which talks about notice. A judge has to give notice if the judge is going to find probable cause to transfer a case on a lesser included offense. Notice isn't at issue here. And then Commonwealth v. Imbruglia, which talks about certain tactical advantages that the Commonwealth could gain from a continuance, for instance, if a witness is no longer available. So I think the posture of this case, since it's at the plea stage, these are not issues here. And the juvenile points to the prejudice as a more severe sentence, which again, the Commonwealth would argue that that's a mischaracterization, although certainly would admit that there is a liberty deprivation here. So I think we have to weigh this potential prejudice against the reasons for the delay. And the Commonwealth's position is that the reasons for the delay are to effectuate the intent of the legislature and therefore outweigh the any prejudice that this court might find. And if the court has no further questions, I would rest on my brief.